All right, we're back on the record, and defendant is present with counsel. Assistant State Attorney is present. Ms. Jensen, just to go back to the verdict form, like I said, I've had folks doing research. Is there a reason you decided that you don't want to do an interrogatory on first-degree murder?
Because it doesn't matter. I mean, it's first degree is life.
I understand. I just wanted to ask the question.
I don't. I mean, it's not a discretionary sentence. It's life in prison without parole. It's a capital felony. I mean, if I need to put it in there, I can. I don't think I ever have in first degree.
Mm-hmm. I'm just going to get one of my staff attorneys to speak on this, and then we want to get this in the record so we're clear on it.
Sure.
Just a concern we had was, I think there's actually a case pending right now where there's a life sentence imposed, but the minimum mandatory for a firearm wasn't imposed. And there's a concern that if a minimum mandatory is not imposed, then that's an illegal sentence. And it's just easier to impose a minimum mandatory if that becomes necessary if you have a clear verdict form to bind into that.
I have no problem doing it.
Mr. Barry Barossett, we would just be under first-degree murder. It would have the three interrogatories of the second-degree murder. Would it be all three interrogatories?
How does it benefit the defendant?
It doesn't. I mean, it's just a clarity issue in my mind. It's not required.
It doesn't penalize the defendant. It just is a clarity issue so that there can't be an argument that there was...
So then what happens if, because you know jurors do crazy things sometimes, so what if they came back guilty of first degree murder but then answered no to the interrogatories, but the way that the victim was killed was by shooting?
Yeah.
And that's why we wanted to ask.
Well, if you both say you don't want it, we just wanted to make sure we had a conversation about
But
it.
you see if that, I know Jeff Gaddy back in the day tried a manslaughter with a firearm, and they came back guilty with the manslaughter but not the firearm, but the victim was killed by a shooting. So, I mean, that just causes me...
Okay, then,
concern.
and since Mr. Barry Barossett does not seem to be enthusiastically bracing it either, correct? We'll just leave it as it is.
Are you still going to do first-degree murder with a firearm?
Right.
Yeah, but I'm actually going to ask Ms. Jensen to add one more word, and it's because this is how it's described in the jury instructions. I'm going to say guilty of first-degree premeditated murder. And the reason is that when you come to the instructions, it says to prove the crime of first-degree premeditated murder. So I'm wanting it to mirror that. So it would be guilty of first-degree premeditated murder with a firearm as charged in the indictment. Do you agree, Barry Barossett?
I agree, Your Honor.
Okay. Okay.
I think we're good, Judge.
All right, thank y'all.
Thank you, ladies.
Thank you.
All right, so we're back on the instructions, and Mr. Barry Barossett, you're just going to have to say if you have an objection. We've got 3.1 introduction, 3.2 statement of the charge. If we want to be consistent on statement of the charge, we could say first degree premeditated murder with a firearm. Just to be consistent. You agree, Ms. Jensen?
That's fine.
Okay. And then from
Why
the...
would we put with a firearm when there's that instruction about, what is...
Well, you're right. Well, I'm just trying to be consistent with what we've got on the verdict form and then the statement. Now, once we start talking about first-degree murder, we don't have to keep saying that over and over again. There's a reason they suggested, I'm going with the staff attorneys, that we include with a firearm. Okay, so that's 3.2, first-degree premeditated murder with a firearm. Then 7.1, introduction to homicide. Any objection, Barry Barossett?
No.
Justifiable homicide. Any objection?
No.
Excusable homicide. Any objection?
I'm going to take those out, right? Justifiable and excusable, since it's not an issue, your defense is not.
Okay, you guys have to speak up if you want it on the
I'm
record.
just asking if they
Yeah.
want justifiable and excusable, because,
They're saying she didn't do it.
right,
I've never had a first-degree murder case where they didn't define it by justifiable and excusable, even though it's not a defense in this case, you know, I'm just.
you want to leave it? Okay.
Barry Barossett, do you want to leave it? Okay, then we'll leave it in. Then we go to 7.2, murder, first degree. On that page, that first page, any objection?
That's a standard jury instruction.
Okay, now that takes us to that first, give only if there is evidence the defendant acted in the heat of passion on legally adequate provocation.
No,
That would not be applicable. Do you agree, Mr.
I
Barry?
agree, Your Honor.
Barry Barossett? Okay, so that, all of that, Ms. Jensen, I believe would, after give only, would be struck.
I understand.
All right, then we have 3.4, lesser included crimes or attempts, and it's second-degree murder and manslaughter. Do you agree, Barry Barossett? Those are the lessers.
Yes, I do.
Okay, so that takes us to murder, 7.4, murder, second degree. If you will look at the first part of that and let me know.
First part, first 6 paragraphs look okay.
Okay. Do we agree that there is no evidence that the defendant acted in heat of passion?
Yes.
And that will be again removed for the remainder of that instruction. We have 3.3D, possession of firearm and discharge causing death, which pertains to the second-degree murder and the interrogatory. Let me know, Mr. Barry Barossett, whether you agree.
Let's take a look here. That looks verbatim of the standard, no objection.
Okay, thank you. Then we go to the second lesser included, which is manslaughter. And I will give you an opportunity to read over that.
Again, that was to track pushing standard instructions. I don't see any reason to change.
Okay? And then we have 3.3A, which pertains to manslaughter, the interrogatory, aggravation of felony by carrying a firearm.
Looks okay, Your Honor.
Okay. Then we get to our standard, 3.7, plea of not guilty, reasonable doubt, burden of proof.
Looks good.
3.9, weighing the evidence, 1 through 5 are standard. So let's go to number 6. Any request for number 6, money, has the witness been offered money preferred treatment?
I see no evidence of that.
Do you agree? All right, so number 6 is removed. Pressure or threat?
I'm not aware of any.
No, I'm not aware of any either.
7 is out. Inconsistent statement?
Yes, we want that.
Okay. 8 will become number 6. Conviction of a felony?
Yes.
Yes. 9 will become number 7. General reputation?
No.
I would like it, but no,
Okay.
there's no evidence.
No evidence, number 10. So it will just be 1 through 5, and then inconsistent testimony and conviction of felony. I think the rest of it, towards the end, there is a give only if defendant testified paragraph, which should be removed.
I missed you there. Which one, where were you there?
Top of page 9.
Top of page 9.
Yes.
Okay, that'll be removed, and then the remainder of that is got to do with talking to witnesses.
Correct.
Then 3.9A, you're requesting both paragraphs, Barry Barossa,
Yes.
okay? And 3.9B,
South.
defendant statements,
Excuse me. Yeah,
okay? And
that stays.
yes, yes. 3.10, rules for deliberation. We need to remove number 7.
Agreed.
That's about jurors asking questions. Other than asking questions about snacks, I don't think they have.
Okay, we're on the cautionary instruction.
I didn't know where we were. Cautionary instruction, yes.
That looks good.
Verdict. I will read the verdict form to them.
Yes.
And then 3.13, I did not let them have their electronic devices. So we can remove that.
Electronic communication.
Right. No. Paragraph 3 under 313, since I didn't allow them to have their devices, they don't need to leave them on their chair. They're in a lockbox.
Okay.
Okay? Okay. All right, Ms. Jensen, I'm going to go in a second, once we confirm there's nothing else. I'll kind of go through it one more time, make sure we have it all. And anything else from the state that's requested? Mr. Barry Barossa, any other requests?
Yes. Now, it may be in here, but I didn't see it. There's been a lot of evidence of things other than what she's charged with. And I know that under 2.4, there's a line there that may be appropriate. Unless it's somewhere else there, but I don't remember seeing it. Where it says the defendant is not on trial for a crime, wrong, or act that is not included in the indictment. There's been alleged theft and so on and so forth.
What does it say?
This is under evidence of other crimes, wrongs, or acts, but I'm not asking for the whole thing. I'm just asking, the defendant is not on trial for any crime, wrong, or act that is not included in the indictment.
There was evidence of purchase of cocaine.
Right.
Well, yeah, I don't have a problem with it. I just didn't know what he was talking about.
Okay, well, let's figure out where it would go. Where is it falling in the instructions?
Well, it was 2.4, but that was, so I think it would have to go.
They're not necessarily in numerical order.
I know where it goes.
What if we added to 3.10 rules for deliberation?
That would be good.
That you could make it,
Number 8.
Number 8. So I want to make sure that you, uh-oh.
Oh. We did something
You're
wrong.
talking, there's a possum in this envelope.
Thank you.
Okay, so can you tell me what you wanted to say? And it's 2.4?
Yeah. Yeah, just put in there, like above where you said 7, we're going to put this in for number 7 there. Remember,
For 8.
well, you knocked out 7, so I was just going to put it in there, but that's okay, however you want to do it. Remember, the defendant is not on trial for a crime, wrong, or act that is not included in the indictment.
Okay, you're going to have to say it more slowly one more time. So, have you
I
got it?
got it, it's in 2.4, right?
Yeah.
That first sentence, I guess.
Got it.
With remember, the last sentence.
Last sentence. Okay, sorry. I
It
wasn't.
says however, just put remember instead of however.
Remember.
And we're going to put that in 3.10.
Yes.
Okay, is there any other instruction that you're requesting? For example, one that comes up, but I don't think it has anything to do with this case, but I'm throwing out, is eyewitness identification. But that's not an issue. So, anything else defense is requesting, Barry Barossett?
There were some statements made out of court. I think that there should be an instruction on that. It should be received with great caution.
Yes, we have defendant statements in here.
Okay. I may have breezed over it already.
That defendant statements on page 9 on the bottom. 3.9D.
Yes, that's the one. Right.
Okay, so Ms. Jensen, just to revisit quickly. On the verdict form, the only change is it's going to be guilty of first-degree premeditated murder with a firearm as charged in the indictment. And give me 1 second, I was just going to make double sure with the indictment. Look at it one more time. There it is.
I got the indictment, Your Honor.
I'm looking at it, I've just got to look at it in the right place. It mentions premeditated and it talks about firearm. So that's what that'll read. Then going to, you with me, Barry Barossett?
Yes.
Okay. And the reason I keep saying Barry is to distinguish between Barry and John, so. All right, then 3.2 statement of the charge, so that matches what's on the jury, the verdict form. It's going to be first degree premeditated murder with a firearm, just in 3.2. And then I showed on page 3, the state's eliminated anything about heat of passion under first degree murder. And then page 4, eliminating anything on page 4 about heat of passion under second degree murder. And then on page 8, eliminating number 6 and 7, including 8 and 9, but they'll move up in the numbering. And so eliminating money preferred treatment, pressure or threat, and general reputation, but inconsistent statement and felony conviction would remain. Then on top of page 9, eliminate give if only if defendant testified about the defendant being a witness. That's about 2 lines. Page 10, somewhere on 3.10, Ms. Jensen's going to add that 2.4 language you've requested. On page 11, under 3.13, she's eliminating anything about them having their cell phones in the courtroom. And that's all I had. And then she will email it to us, and John Barossett will look at it tonight and let us know. I'll also look at it tonight or whenever I get it. And then, Branda, you don't work for me, but since it's nice that y'all bring copies, we have 15 jurors, Court Reporter 16, 17. 21 copies, plus 1 verdict. Ms. Jensen, can you think of anything else that I can do for you today?
No, ma'am.
Mr. Barry Barosik, can you think of anything else I can do for you
No,
today?
thank you, Your Honor.
Mr. John Barosik,
No, ma'am.
I have gotten confirmation. Again, everyone in the building is working on this case, I think. Michael will meet you at 8 o'clock or 8 o'clock or 8:05 and be available to answer any questions or check out the plugs and all of that sort of thing.
Sounds great, thank you, Your Honor.
All right, if that's it, I'll see y'all tomorrow at 8:45. And Ms. McArthur's now gone.